privacy. Is something like that even possible in a country of 1.486 billion people? A country where the vast majority of people live in thick, densely populated societies. Some may even say that privacy would be mythical, an illusory concept in India or Bharat. Well, whatever you may believe, privacy is now officially a law in India. Yes, that's right. After a long wait of 6 years, India's first complete legislation on privacy is now here. It's called the Digital Personal Data Protection Act of 2023. So, to give you some context, let me throw light upon the history of this law in India. In the year 2017, the Supreme Court of India, in the case of Justice K.S. Puttaswamy and another versus Union of India, recognized privacy as a fundamental right. In the very same judgment, the court also expressed the dire need for a law on privacy in India. Over the next 6 years, there were multiple bills floated on privacy. Committees were constituted and deliberations were done on the subject. It finally became law now in 2023. So the older rules that were in force applying to sensitive personal data, called the SPDI rules, have now been repealed with the passage of this new act. So the act applies to processing of personal data within India in digital form or in non-digitized form, which is digitized subsequently. It also applies to personal data outside the territory of India, if such data processing is related to goods or services that are being offered to persons in India itself. So now let me run you through the main provisions of the Act, the ones which should matter to you. So first of all, the Act defines persons whose data is being taken for processing as data principals. The entities which are taking and processing the personal data are called data fiduciaries. They're called data fiduciaries as they are being entrusted with data. Processing here means operations performed on digital personal data, such as collecting, recording, organizing, storing, sharing, or erasing data. And the data fiduciaries must have data protection officers and grievance redressal mechanisms in place. The Act also provides for a data protection board, whose officers shall be appointed by the central government. This board shall consist of a chairperson and other members and shall act as a forum to decide upon complaints related to data issues under the Act. Now, the board must give reasonable opportunity of hearings to parties in cases brought before it and pass orders in writing with supporting reasons. This board shall be an independent body. Another interesting thing about it is that it shall function as a digital office. Just like other courts and forums, the decisions of this board can be appealed against, and such appeals shall go before the Telecom Dispute Settlement Appellate Tribunal. This is a tribunal which hears a lot of telecom and cyber law related cases. I have appeared before this tribunal called the TDSAT a lot of times. So the Act says that in order to collect a data principal's personal data, the data fiduciary must send them a notice to obtain consent. And this notice must inform the data principal of the purpose for which the data is being collected. It also must inform data principals of the manner in which they can withdraw their consent for processing of the data if they wish to, and the manner in which they can approach the grievance redressal officer if they have a grievance or file a complaint with the Data Protection Board. The form of the consent given is also specified. It must be free, unconditional, and specify the purpose for which data is being shared. Now, since we're talking about consent, I must tell you about a very new, unique concept related to the same, which is provided under the Act itself. And this is the concept of a consent manager. Now, the consent manager is a person who shall be registered with the Data Protection Board and act on behalf of the data principal. This person shall be a single point of contact through whom the data principal can give, message, review, and withdraw their consent to processing of their data in a transparent manner. So most of the people listening here would likely be data principals, right? Or people who are giving your data to others, to data fiduciaries, these big entities to process that data or store that data. So now let me tell you about all the rights that you lucky people have, all your data principals. First of all, you have the right to withdraw any consent that you have given a data fiduciary to process your data. Secondly, you can ask the data fiduciary for a summary of personal data that is being processed and processing activities that they're undertaking with respect to your data. You can also ask them for the identities of all the parties that they have shared your data with. Thirdly, you have the right to ask for the erasure, correction, completion, or withdrawal of your data. Fourthly, You have the right to seek redressal of your grievances and make complaints for any violation of law or breach of your data by the data fiduciary. Now, let me tell you about the obligations of data fiduciaries under the Act. For any of you big tech company executives listening out there, please pay close attention, as complying with these laws could save you a lot of money, right? So you'll thank me later. First of all, the data fiduciaries must have reasonable security safeguards in place to keep the data that they have collected secure to prevent any data breaches. Secondly, data processors can be engaged by data fiduciaries through a proper contract by these data fiduciaries. Thirdly, in case of any data breach, they must inform the data principal and board. Fourthly, they must erase the personal data upon the data principal withdrawing consent or as soon as they find out that the specific purpose which the data was collected is no longer being served. Fifthly, they must publish information about the data protection officers and grievance redressal mechanisms. Sixthly, they must obtain prior verifiable consent from the guardians of children or disabled persons to process their data. However, they cannot process any data of children which may have any detrimental impact on them, right? Without taking proper informed consent and all that, and they cannot actually process any such data at all, to be very honest, right? If collecting a certain kind of data has a detrimental impact on children, then they cannot collect that data, irrespective of whether or not consent is being given. And they cannot track or monitor the behavior of children to direct targeted advertisements at them, right? So you know what targeted ads are: ads which basically make you want to buy something, entice you, and they're targeted at you specifically because knowing that you are the kind of person who's likely to be a target customer for them, they target these directed ads to you. So you cannot do that with children. And the data fiduciaries may disclose data if they're required to do so under any law to any state agency or in the interest of security and sovereignty of the country, right? So basically, that means that if something poses a threat to the security of India, to the unity or integrity of India, to a country as a whole, so a data fiduciary may be required by law upon a demand being raised by a state agency to disclose that data, right? And then penalties. The Act provides for penalties in hundreds of crores for violation of provisions of the Act, right? So those are some of the most important provisions of the Data Protection Act. I personally feel that it's a very good law, right? It will be implemented in stages, and we are yet to see how it turns out practically, how it actually comes to fruition. I personally feel the processing of data of children is an area which needs more clarity and refinement, right? As of now, they have put almost a blanket restriction on processing of children's data, and that might not be practicable. I also feel that they have secured the interests of data principals, that is, the billions of citizens of the country whose data is processed every day. People will now know that their data is being used. What's important now is to spread awareness amongst the masses about how the data is being used by data fiduciaries and processors. They must understand the intricacies of these laws, and as data principals, be actually able to exercise their rights, right? At the same time, data fiduciaries need to be made aware of these laws. They need to, as lawyers, we need to help them put proper systems in place so that they can save hundreds of crores, right? Not end up paying penalties, and also have a good relationship with their customers, the millions and billions of data principals who they're taking data from. Compliance with the law has now been simplified, right, due to the lucid language of this act. So it is important that the constitution of the Data Protection Board is solid to ensure that the law is properly implemented and disputes are resolved with ease. So let's see how the implementation of this act unravels. I hope you're excited as I am. And stay tuned for more episodes on my channel. Do not forget to like, share, and subscribe to the channel. Thank you.